Well, good morning. Welcome, everybody. Welcome to Dorset Council's Licensing Subcommittee. My name's Derek Beer. I'll introduce everyone in the room. Then we'll do something a little bit, we'll go through the formalities, and then I'll explain the procedure for the meeting. Is that okay? We are being live streamed, so if you can speak into the microphones, please. Can you hear me okay, Tarek? Yep.
Yes, can hear you fine.
Good, thank you. And any questions, put them through me, and then we'll keep everything in the right sort of order. So my name's Derek Beer. I'm Chairman of Dorset's Licensing Committee, and on my right I have...
Councillor Kate Weller.
Thank you. Go for it. Oh, get off.
And Councillor Craig Monks.
Thank you. I'll do the other introductions while we're here. Let's go to our legal representative.
I'm Laura Orchie from Legal Services.
Thank you. And Democratic Services.
So I'm Joshua Kennedy from Democratic.
Megan Rochester, also Democratic Services.
Thank you. And our licensing team.
Catherine Miller, Senior Licensing Officer and Report Author.
And Aileen Power, Licensing Team Leader.
Thank you. And would you like to introduce yourselves?
Jaspal Ojala, Managing Director at Wiggle.
Susan Stockwell, Objector.
Thank you. And on the screen?
It's Taran Ojala, and I'm the General Manager for all the Wiggle sites.
Thank you very much indeed. We'll now move to the formal part, the introductory formal part of the meeting. May I please have a nomination for Chairman?
I nominate Councillor Beer.
Thank you.
And I'm very happy to second that nomination.
Thank you. What will happen this morning, the licensing officer will present the case to us. We'll then invite the applicant to put their side of how they feel about things, and then we'll ask yourself to put your case forward. At any time, the members might ask questions of either of you at an appropriate point, okay? At the end, when we've heard everything and we've digested and you've all said what you wanted to say and the licensing officers and the legal team are happy, we will retire and consider everything we've heard and come up with a recommendation or a solution which will be notified to you at the earliest opportunity. Okay? Thank you. So we now go to the licensing team to... Oh, sorry, forgive me, yeah. Do we have any apologies, please?
No apologies for the meeting.
Thank you. And any declarations of interest? No. No, I don't either. Thank you. Go over to the licensing team. Thank you.
Thank you, Chairman. Since the Policing and Crime Act 2009 came into force, sexual entertainment venues, which includes any premises which host any live display of nudity, must be licensed under the Local Government Miscellaneous Provisions Act of 1982. In addition to the premises licence they require under the Licensing Act 2003. Up until this time, lap dancing clubs were controlled solely by the Licensing Act. The applicant has submitted their response to the objection raised by the member of the public. However, this was unfortunately not included in the original report. Members have been given a copy of this, as has the objector. Licences for sexual entertainment venues remain in force for 1 year. Like Licensing Act applications, renewals have to be advertised and consulted within specific timeframes, and this is all being complied with. Any person can object to these applications, and this application has attracted one objection within the statutory time period. Where this Act differs to the Licensing Act is how objectors are treated. There is a presumption of anonymity unless the objector gives consent to have their name released to the applicant. The authority must give the applicant a right of audience before making a decision and must take into account any observations from the police. Whilst the objector has no similar provision in the Act, it is good practice to allow them also to address the committee making a decision. There are two sets of grounds for refusal of application, the mandatory ones and the discretionary ones. The mandatory ones relate to age, UK status of individuals and companies, and that an applicant has had an application for the same premises refused in the past 12 months. None of these apply in this case. Its discretionary grounds for refusal are that the applicant is unsuitable to hold a licence by reason of having been convicted of an offence or for any other reason, the fit and proper test. The applicant is fronting the application for someone unsuitable, that the number of sexual establishments exceeds the number deemed appropriate in a policy, and that the layout or location of the premises is unsuitable. Conditions may be attached to the hours of opening and closing of sex establishments, displays of advertisements or in such establishments, the visibility of the interior of sex establishments to a passerby, and any standard conditions usually prescribed within the policy. Appeals are available only to applicants and only to refusals under the first two discretionary grounds. There is no right of appeal refusals based on the number of establishments in the area or the suitability or location of the premises. The former area of Dorset Council that had a working SEV policy was Weymouth. This is because there are only 2 SEVs in Dorset Council area, both of which are in Weymouth. The policy was enforced between 2016 and 2020. This policy is yet to be replaced by a Dorset Council policy. This does put a question mark over the validity of the policy. I would suggest that it should still be regarded as persuasive in your deliberations due to the fact that it was and is still a working policy, as is written for the only 2 licensed venues in Weymouth by the former Weymouth and Portland Borough Council. The objection relates to the suitability of the applicant, the suitability of the premises location is unsuitable, and the layout, character and condition of the premise is inappropriate. This matter was brought up last year, and as we advised the committee last year, they will need to decide whether they think a civil fine is a relevant matter and how much weight to attach to it, and balance this against the lack of concern from the police and a history of no complaints being received about the premises since Mr. Odger took charge of it. With regard to the location, members will need to bear in mind that this is a premises that has been in this location for over 10 years, and apart from the 2021 renewal, has never been in front of a committee. Well, it was in a committee last year. That hearing came about because someone had moved into the area and not realised the premises were there until the renewal was advertised. I'd also draw your attention to the fact that neither the ward member nor the town council have objected to the renewal. Thank you.
Thank you very much. Members, do you have any questions on that report? No? Okay, thank you. And who'd like to put the case for the renewal of the licence? For yourself, sir?
Sorry, we've actually sent in a written response to each and every one of the questions. I think Taryn Ojala may want to say some things on our behalf, but all I'd like to do is emphasise that none of the relevant authorities have ever put in an objection against our licence. And I don't want to waste your time because all the responses are there.
And you're quite happy with the procedure and everything else that you've heard? Yeah, no problem. Yeah, thank you. So, Tarek, would you like to, was there anything you'd like to put to the committee at this point?
Just firstly, good morning, everybody. Just very quickly, once, as my father just said, we've enclosed a written response. So every one of the points that Ms. Stockwell has raised, once again, these are repeated points, very similar to last year's, which were considered, duly addressed last year. So we've enclosed a written response to everything. If there are any questions that you'd like to put forward to us, we're more than happy to answer them. But once again, no objection has been raised by the police. And as far as I'm aware, we've had none from any other local residents of Weymouth, none pertaining to noise. The only thing that Ms. Stockwell has raised is a civil fine as raised by licensing, but that's entirely up to you to consider. But again, this was also raised last year and duly addressed.
Okay, thank you very much. I just asked my colleagues if they have any questions for either of you.
No, happy.
No, you're happy? Okay, thank you. In that case, if there are no more questions from anybody, we'll go across the objector. Would you like to put your points over, please, Madam?
Thank you, Chair. This is my objection to the current application for a sex establishment licence for the sexual entertainment venue SEV, trading as Wiggle Strip Club in Weymouth. Suitability of applicant. And can I just hop back to your officer's report here, that My understanding on the suitability was that, so sorry, I can't see where my note is. Oh, here we go. Yes, my understanding was that it could be for any reason that you refuse a crime or any reason. However, obviously you need to be reasonable. So any reason makes anything relevant, but you need to behave reasonably. So I would say that what I've raised is reasonable to include. But I noticed that your officer added the words "that fits the proper test." Now, I haven't seen that in the legislation. I assume that that's basically an administrative law point, that you need to behave reasonably rather than that's part of the legislation. I'm sorry, it's a bit of pernickety, but it's, you know, it has come up and it's different from my understanding of what the legislation says. So
Ask the licensing team, are you happy to deal with that?
I'm happy to deal with with that. I think the legislation does say quite correctly that it's for any reasonable cause. I think the general consensus of licensing officers and the years and years that we've been doing that, this is a fit and proper test of an applicant. It is very similar to the fit and proper test we use for a taxi driver. So it's a principle of deciding whether an applicant is suitable, whether they're fit and proper.
Thank you very much, Aileen. So, are you okay? You understand that? Yeah. Oops, sorry.
I'm obliged. Thank you. As mentioned last year, the applicant is unsuitable because of a fine paid for an unlicensed HMO in Portsmouth in Hampshire, and I'm obliged to your officer for correcting that I'd made a mistake putting in Dorset originally when I submitted, as you'll see from Mr. Ojala Jr.'s statement. And because at time of writing, his club in Southampton has work outstanding on a building control matter. Now, Mr. Ojala's statement says planning and licensing is complied with, and I certainly don't disagree with that. But it's a building control matter that when I wrote the objection was outstanding, and that was on knocking basically, I think, a door through a wall. Neither of these are listed in your policy for suitability of a licensee, but I would suggest it's perfectly reasonable to refuse a licence on the basis of non-compliance in another licensing area or requirement from a council department. Suitability of location, the neighbourhood. This location is in the vicinity of this esplanade. Last year, the Chair of Licensing and I think, got our wires crossed as I objected on the same grounds, but the Chair gave the impression I was concerned about people stumbling across the actual premises, which I was, but I was also concerned about the premises drawing in people unsuitable to be in a family resort and liable to move around the neighbourhood of the strip club, making a nuisance of themselves. Their own staff handbook, filed in Portsmouth City licensing hearing, refers to obnoxious and regulars, whilst a similar document for another very experienced operator, FYEO, warns staff of danger from customers away from security provided at their workplace, and warns against visiting late-night bars after shift in case customers are still around. And if I can again touch on Mr. Ojala's statement that the licensed premises are a safe place for their staff to work. The last time I looked at their website and on several other occasions, they were still advertising performer hire so that you could take people, they're offering to facilitate taking their performers and having them work at other presumably unlicensed, but not clear. Now, it doesn't specifically say that you hire the performers to do the same work of sexual entertainment, but it definitely doesn't say that they are not offered for sexual entertainment, but for other purposes. So I'd just like you to bear that in mind on the safety aspect. Crown v Newcastle-on-Tyne ex parte Christian Institute includes comments by a judge to the effect that a sex establishment will attract people of dubious morals, and that is why you would not want to licence them at locations where, say, children are present. In this case, of course, many children visit the Esplanade and beach. Can I just emphasise, I don't want to give any impression that there are children entering these premises. That is I realise that could be implied from a quick read through. That is absolutely not my intention in this objection. I'm not suggesting that at all. Use to which other premises nearby are put includes at least one holiday home for which I have read a review saying that the noise from the club had kept her awake. In fairness, though, a counsellor I approached told me he had never had any noise complaints from this club, but had from other venues along the front. Now, I've been through my emails last night because I read your officer's report that no ward councillors had objected. And in fact, I can't find that email, so I don't have anything to back that up except my memory. I think it's more likely that residents would complain to a councillor rather than holidaymakers do so. There are historic buildings further down the street and other things of interest to holidaymakers which will bring them into the area. From what I can gather, the Weymouth Bowl and the Peninsula are earmarked for regeneration, and both are about 5 minutes walk away from the premises, so in the vicinity for the purposes of regeneration. The point is that if the regeneration is aimed at people that include women and children, then the presence of a strip club is a deterrent to investment. Women want to be able to walk around an area safely at any time. If you have to park a distance from your home, holiday home, or workplace, you don't want to be encountering strip club customers in the street when you are on your way between the car and destination. Suitability of premises. From memory of last year, the plan doesn't show any area for smoking, which will mean people gathering in the street, which may be noisy and will also be intimidating for anyone making their way through the throng on their way back to a holiday home in the Old Town area. Now, I acknowledge Mr. Ojla Jr.'s comments that their staff are instructed to stop any sort of disturbance happening, and I have no reason to disbelieve that at all. So if you want to take that into account. As I tried to explain last year, someone who doesn't know the area will use a navigation aid on their phone after an evening out on the Esplanade, for example, and risk being sent past the club on foot. Could you excuse me a moment? I say that you will be breaching your public sector equality duty by licensing a strip club, given that it will go against your duty to improve relations between the sexes. The club's website uses or has used images of a manager, and that is, I recognise from the picture here, Mr. Ojla Jr., standing in what I consider an overbearing manner over one of his staff, who is wearing a costume which parodies a girls' school uniform, hardly conducive to healthy relations between the sexes. Now, although the picture that was sort of front page advertising the Southampton club with the girl in that, I beg your pardon, woman in that costume, has been removed, it's still there in the section on how to run your own strip club, so that is still there. If Weymouth uses CSAS officers, then I would suggest that in refusing this licence on the basis of location and breach of public sector equality duty, you will also meet Section 40A of the Equality Act, which is the new duty this year. I beg your pardon, it's actually last year now, we've come forward a year, to take proactive steps to prevent sexual harassment of your employees. Now, I note that Mr. Ojla's statement says that the CSAS manager for Weymouth says that there has been no sexual harassment of his staff as a result of this club existing. However, the Section 40A is a proactive measure rather than rely, as your licensing is, rather than relying on something happening before you take action. You already have the Pineapple Project to give women and girls outside of the home places of refuge from unwanted male attention or sexual harassment in public places. How much better to support that work by stopping licensing an establishment that objectifies women and encourages the obnoxious behaviour mentioned in Wiggles' staff handbook above, which damages relationships between men and women in the home, in public and in workplaces. This is a reminder that there is no legal requirement to prove harm in a licensing refusal, as your action can be proactive. Could I also add to that, building on your officer's address, that there is the difference of me as an objector having to waive anonymity before I can be named. That's compared to the Licensing Act 2003, the alcohol and late night licences. There's another difference that the Licensing Act 2003 specifically puts the burden of proof in a refusal on you as the licensing committee. That isn't written into the legislation for licensing a sex establishment. Now, I interpret that as there is no burden of proof on you. At the very least, it's neutral, and possibly the sex establishment has the burden of proving that this place is needed. Another licensing authority, not this council's, has argued to me that the burden of proof is on the licensing authority to prove in a refusal, which I don't agree with. I just leave it with you to perhaps take advice from your officers on that point. Then say there is also no presumption in favour of licensing sex establishment. I should have said statutory presumption in favour of licensing sex establishment, unlike that in Licensing Act 2003 applications. Lastly, the committee can make a different decision than last year, even if the circumstances remain identical to last year, according to the Crown and Birmingham City Council ex parte Shepton Hurst Limited. And there is something else that came up when I was looking at your officers' papers last night that were published on the website, which I didn't have, I could have had access if I'd really looked for the policy, but I didn't. And at the very end of your policy is that the advertising can't show any indication of nudity. Now, I would perhaps invite the applicant to show you the logo that's displayed on the outside of the shop. I don't have a copy of it to hand easily. I say that it does indicate nudity, and I think that's the reason that they've been removed in Bournemouth, although Southampton didn't ask for them to be removed. So, obviously at your discretion. Thank you, Chair.
Thank you very much for your very comprehensive presentation. I should now come to members to ask any questions of you, but I'll just go to the officers. Did you want to correct either of the points that the objector made about your report or the anonymity?
I think I'd leave it to legal to do the burden of proof one, if that's all right. What was the other one? So the legislation is different in the Licensing Act and Local Government Miscellaneous Act, which covers the sex establishment one. That they are, under the Licensing Act, they have to request anonymity, whereas under the sex licensing, under the Miscellaneous Provisions Act, they have the, we start with the other way around. So we start with anonymity, and then if they give permission, then they can be named.
Thank you very much indeed. Thank you.
Do you want me to comment on the other point? I think basically it's a matter for you as the subcommittee to decide what weight you're going to give to all of the information presented to you and then come up with a decision.
Absolutely, thank you. Members, do you have any questions for the objector?
I wonder, have you, I'm not trying to put you on the spot here, but have you actually visited the establishment when it's been open?
No, I haven't visited the establishment, open or closed.
You haven't had an opportunity to speak to the performers or the staff at all?
That's not part of my objection. It's not unusual to see objections to strip club licensing based on concerns for the performers and staff, but that's not part of my objection at all.
No, I just wondered whether you had. Thank you.
Anyone that has approached me that's been staff, I've told them that they need to make their own objection. It's very difficult when I've had people approach me anonymously that don't want to go ahead. Thank you.
Okay. Thank you. I don't have any other questions. I think you've put that well, and we've weighed it up. Thank you very much. Was there anything you'd like to come back on what we've heard so far? Anything you'd like, any points you'd like to pick up? Anything you'd like to add on any of the points that have been raised?
I have nothing to raise on those points. However, I would like. I would like to say that we have invited people to our premises. We've got nothing to hide. We operate properly. Licensing have been in. They've questioned our performers and looked at our premises thoroughly. We abide by all the conditions. Thank you.
Thank you, Taryn. Is there anything you'd like to add? Having heard the objections, is there anything you'd like to add at this point?
Just very quickly over Ms Stockwell's points. In regards to the building control matter, we're not aware of any building control matters that are outstanding or have not been complied with, and we don't really see any relevance to the SEV renewal to our premises in Weymouth. I mean, this pertains to a completely different building, has nothing to do with the licensing process. I don't think it would affect the suitability of the applicant or our application. The location of the SEV is being raised again. This was addressed at last year's committee meeting. The mention of staff handbooks. The objector hasn't provided any evidence to the statement of obnoxious customers. I can personally tell you that that word is not included in our staff handbooks because I personally wrote all of our staff handbooks and did not mention obnoxious customers or anything within any of those handbooks. I would ask the objector in any of her future objections to provide evidence to this. The mention of FYEO, a competing club's policy, has no relevance again to this SEV renewal application because it pertains to a completely different business. Going back to the point, I think in her spoken statement just then about hiring out performers, we don't recognise any hiring out of performers, and it is not something that we do. On our website, we do quote that staff will walk our performers to their designated mode of transport at the end of their shift. And this is advertised on our website as it's something we're quite proud of, that we do look after our performers. But this notion of hiring them out is not something that we do or have ever done. And then just going to the noise from the club, we have had no noise complaints from environmental health. So we, again, don't see any relevance to this in our SEV renewal application. Thank you.
Thank you. Members, have you any other questions for the applicant? No? Thank you. Legal team, have we covered everything?
Don't know if your licensing officers want to add anything, but other than that, yes.
Anything else, team?
Just to confirm, there were no objections for environmental health regarding noise or anything. The smoking, I think I put in my report that premises aren't legally obliged to provide a smoking shelter for customers. So yeah, that's the 2 points I wanted to clarify.
Thank you. Thank you very much indeed. Team, any questions for anybody else? No? Okay, thank you. Well, if everybody's happy, you don't have to come back. It's not standard procedure, but on this occasion, and I'll allow it, but on the understanding that the applicants can also come back and rectify your comments. But it's not standard procedure. Okay.
I'd just like to confirm that Mr. Osler has indeed invited me to come into his premises, and I haven't taken up that offer. So, you know, he has offered. And on Mr. Osler Jr.'s comments on the staff handbook, I have actually seen things that Mr. Osler appears to have written on the website, and they're in a completely different style than the staff handbook that I found filed in Portsmouth. And I really can't see that it would be something he'd written. It's sort of verges on, like, at different points. It's sort of almost in American English, some of it, as if it's been taken. I mean, it could be it's, you know, completely false and nothing to do with his club. But it definitely doesn't look like something that's written by Mr. Osler Jr. That's all, Chair.
I understand all that, but thank you. Would you like to come back on those comments, sir?
I'm not really too sure what Susan is quoting, anything in American English. I'm really not sure of anything. I would ask that in future, any of these points that you're raising, could you provide evidence to do so? You know, we've got hundreds of documents, hundreds of pages on our website, so I don't think I can comment on any individual post from our website without having the evidence in front of me. If you're going to raise an objection, surely the accompanying evidence or screenshot, etc., should be brought forward with it.
Thank you. I think, sorry, you'd like to add something else?
I do know for a fact that the handbook was written by my son because I oversaw everything, and then I read through it, and it was passed on to our legal team as well. And our legal team actually checked it over as well, because obviously we don't want to do anything that falls beneath our standards. So it's been thoroughly checked over, and we can provide you with a copy of it if you would like.
Thank you very much, members. Any more questions on those last points? Well, I think we've listened to everything. We've gone through the procedure properly. We've got lots of things to look at in front of us. We will withdraw now and make our decision. And that decision will be notified to all parties within a reasonable time. Okay. There is the right of appeal. No, there's not. Yes, there is. Appeal may be made to Weymouth Magistrates Court within 21 days of the notification. Okay. Everyone understand what's happening now? Yeah. Sorry?
It's for the applicant.
Sorry.
Just to confirm, Chair, so the right of appeal is for the applicant?
Yeah. Yeah. Thank you for correcting that. Right. Do we have any urgent business? No, thank you. And any exempt business? No, thank you very much. With that, Mel, thank you for your attendance this morning. Thank you very much indeed for taking up the time. And I wish you well for the rest of the day. Thank you.